Before I begin into giving the presentation, I wanted to share a quick story about my worst job interview that I've ever had. So I was interviewing for a company that was out of Colorado. That's where they were. I was here in San Antonio. So they agreed and set up a video interview for me that made sense rather than flying all the way up to Colorado for an initial interview. The day of the interview, they gave me a call and said that they were having problems with their audio equipment. And so they wanted to do the video portion of the interview, but then do the audio by calling into my cell phone. That was fine. So that's what we did. I thought the interview went fairly well. Apparently, I may not have been so attuned to what makes a good interview because we got done with the interview. They said their pleasantries and they would let me know, how it went and all of that. And then they hung up. Well, the problem was they hung up the video portion only. They also had forgotten that they were on my cell phone, on their phone, talking with the audio portion. So when they hung up the video, the audio was still connected. As a result, they immediately, like the second that we hung up, started going into on how horrible of an interview that it was and what a bad job apparently I had done. This obviously created an instant ethical dilemma on what do I do and how do I handle this situation. I thought about getting snarky and making some sort of snide comment and hanging up on them or getting angry with them or something along those lines. What I did instead was I kept listening because I figured this might be an opportunity for me to learn, unfiltered information on how I can improve my job interview skills. So I listened for a few minutes as they continued to effectively bash me and how I did on the video interview. And then they moved on and started talking about other candidates. It was about this point that I'm like, okay, I got to stop listening. So I quietly hung up my phone and then proceeded to, I think, hide for the rest of the day. Anyway, the whole reason that I'm telling you that, it was a horrible interview, and I obviously didn't get the job. The reason I'm mentioning that is that I still, to this day, and this was several years ago, have a hard time talking directly to a webcam like I'm doing now. So for the rest of the presentation, I'm going to switch to a voiceover only narration of the PowerPoint because I'm a little more comfortable with doing that. Okay, I think that's better. In case you don't know me, my name is Kevin Patrick. The topic I'm presenting on today is social media usage versus employment rights and how those are getting intertangled with employees and their companies. What we're going to discuss is the overall issue of what is going on, provide a bunch of recent examples, look at the precedents that can maybe be applied to the situation legally, federal statutes, guidelines, etc. Provide the analysis of those recent examples so that we can glean off some recommendations, primarily aimed at the employee, on how to avoid some of the intertanglings and the negative consequences of inappropriate social media use. The main issue is this: when people are using their social media outside of work hours, and then whatever that activity is goes maybe viral, they then get fired from their job as a result. And so I think the ethical issue comes down to rights of the individual versus rights of the company, and which one takes a higher priority and which one should take a higher priority. Ultimately, is this an ethical issue? Is it a legal issue? I think if you ask most people, they would say that what I do outside of work has no bearing on what I do in work. But I think that we've seen, and we'll look at examples where that has been completely proven untrue, and the two sides are getting completely entangled. Looking at recent examples, we'll start with the Las Vegas shooting that occurred in October 2017. You can see the Facebook post here that got the employee in trouble. This person was an executive in the legal department for a national TV network. The post talks about how she didn't have any sympathy for the victims because they were country music fans. It was a country music concert, and therefore probably Republicans. As a result of this post, she was fired from the company. The next example was several years ago. This was a public relations director who was traveling over to Africa, and you can see her highly insensitive, derogatory post about Africa and the AIDS crisis that she put up on the way over there to Africa When she got to her destination, she found out that she was fired at that point. Everybody's probably familiar with this picture. This was a marketing executive who worked in the D.C. area flipping off President Trump's motorcade. A member of the media who was part of the motorcade took the picture, posted it on social media. People online then discovered her identity, and she was ended up being fired from the company that she worked for. More recently, Roseanne Barr with her racially charged comments. I'm not going to put those up. As a result, her new TV show that she was on was promptly canceled. This one was from several years ago, actually here in San Antonio. Air Force drill instructor posed nude for Playboy. The Air Force found out. She was demoted, court-martialed, and ended up resigning from the Air Force as a result of those particular actions. Very recently, also here in San Antonio, the man pictured here in the Whataburger harassing the teenager who was wearing a Make America Great hat, where that video went viral. He was identified and was fired from the bar that he worked at here in San Antonio. More recent examples, this is the director of the first two Guardian of the Galaxy movies. It was discovered recently, some 10-year-old posts that he had made on Twitter that were fairly inflammatory. As a result, Disney fired him from the third movie that he was set to direct. Here is a police deputy from Washington State. You can see the picture there on the left. That apparently is a logo for a hate group. She's obviously posing with that shirt. As a result of that being posted on social media, the department let her go as well. This is a professor from Idaho who had some sort of conflict with the university leadership, and he started publishing a bunch of critical comments about the leadership, and he was ultimately fired for those comments that he was making critical of the university. This example was from a couple of years ago. An engineer at Google published an open letter about 10 pages long that talked about the gender differences between employees in Silicon Valley and why fewer women worked in the tech industry as a whole. Unfortunately, the tone of his letter was very insensitive and derogatory towards women. As a result, he was fired from Google for publishing that letter. Also in 2016, this employee of Yelp posted an open letter to the Yelp CEO talking about the low wages that Yelp paid and the high cost of living in San Francisco, which is where they were based. And again, she was pretty quickly let go after that letter was published. She was very disparaging to the CEO directly in her letter. In this example, you can see the demonstrator here at the neo-Nazi protest in Charlottesville, Virginia. His picture was published online, and then other people online were able to identify him. He was actually from Colorado, and the company that he worked for in Colorado fired him as a result of his participation in this demonstration. This next example I have a video for. A fan at a baseball game threw a beer can onto the field as the outfielder was making a catch, and it barely missed him. We'll play the video here in a second.
What started as a ball game turned into a police investigation just like this. Hard to tell right away, but it was a beer can thrown from the outfield seats at Baltimore Oriole Hyun-Soo Kim.
As a result of his actions, that video went viral and he was fired position there. I'm sure we're all familiar with this one. TV host Billy Bush, his comments he made with President Trump from about a decade ago were discovered, and he was fired from his hosting duties. And then finally, I thought this one was actually fairly entertaining. A school social media director, they were having bad weather, so the school was going to be closed. You can see the student here wrote in and asked that the school be closed tomorrow, and then that social media director responded with a spelling correction of tomorrow. She was let go a couple of days after this particular post. To start analyzing the interaction between social media and employee rights, we can start with the Constitution. That's probably a great place to start. The First Amendment, which is what most people think of when they think of freedom of speech, here's an excerpt of it. Congress shall make no law abridging the freedom of speech or of the press. Again, most people, I think, go to that on, hey, I have freedom of speech, I can say whatever I want, especially if it doesn't affect work, it's outside of work hours, etc. However, the way that that is interpreted, though, is that the First Amendment pertains to federal government actions. Congress shall make no law. Doesn't talk about non-government companies, privately held, publicly held, doesn't cover that. As a result, individual employees are not really covered under First Amendment protections by actions of the company. So I think that's a little bit of a misbelief that we commonly hold in the states. Additionally, and I think most people probably know this, most states are at-will employment. Montana is the only non-at-will employment state. What does that mean? I can be fired for anything at any point. I don't have to have a reason to be fired. My employment is at will, meaning the company can let me go at any point. Of course, there are certain federal exceptions, i.e. discrimination, retaliation for whistleblowing, if I get called for jury duty, military service, any of those federal discrimination type guidelines do provide protection from that at-will employment status. A number of states have also started to pass other guidelines and statutes to provide some limits to at-will employment. Some of the examples include 42 states currently recognize a public policy doctrine, meaning that the employee cannot be fired if his actions or inactions are taken because of an interest in the public good. If the employee knows that the employer is trying to force something that maybe is illegal or against the public good, that employee can resist that action and not be fired for it. Also, 36 states have implied contracts of employment. This is not a written express contract of employment, but more of that verbal, the boss telling you, hey, you're a great employee, you can stay here as long as you want. Those types of statements or implied contracts do provide a little bit of limit to that at-will employment. Mainly, the employee will have some recourse if they do get fired to try to take legal action to gain their job back. There are a few states, you can see them listed here, California, Colorado, New York, and North Dakota, which have passed statutes that protect employees for legal off-hours activities. However, that's not really completely settled in. It does seem like, as I was reading into it, more of a gray area when it comes to implementation as far as to how those statutes are actually employed for the employee against the company, etc. It still seems like a gray area overall. In addition to the federal guidelines and the state guidelines that are in place, there's also the concept of a company having their own rights. As we know, the purpose of a company is to generate profits, and as recognized by the 14th Amendment, companies have very similar rights as individuals. Numerous Supreme Court cases have upheld the concept that a corporation is a person and therefore has certain rights. For example, right to free speech, right to place ads, right to act in ways that protect their own interests, their corporation. Given both of these facts, though, companies will act in their best interest. And that becomes a conflict when you have employees and their bad social media usage. Additionally, some corporations do have morality clauses that they require an employee to sign as a condition of employment. As an example, a teacher may be limited on what social media type posts they can use because the social media will be scrutinized by parents and the school district. In that particular case, they want the teacher to be a good role model for the students, so they don't want the teacher going off and doing something that might seem immoral, possibly, and therefore maybe be a bad influence on the student if the student were to stumble across the teacher's social media page. You may see morality clauses in maybe religious institutions, Catholic schools or universities or places like that, again, where there's an aspect or a quality of a role model of the employee. Also, be aware that companies use social media in the hiring process. It's just part of the hiring process now. Uh, Sources will say that 70% of companies use social media to advertise open jobs, and over 50% will use social media posts to screen applicants. So again, I think we're all aware of this, that we have to be careful of what we're putting on social media when we're applying for a job. This is kind of starting to spill over into keeping that job. Another source that I saw said over 50% of companies will continue to monitor social media posts even after the employee is hired. So you just have to be aware of that as well. So as a result of all of that corporate actions, they're going to make decisions that protect their brand. They don't want to damage income generation. They don't want to damage their brand because then people won't continue to patronize that particular company. They do have free speech protections, and generally they're not restricted by at-will employment clauses. That gives the companies a lot of power and freedom to do as they see fit in their own interest. As a result, I think you'll see the continued firing of employees who engage in controversial social media posts or other activities outside of the work environment. So when it comes to social media usage versus employment rights, I think here's the crux of the matter. Companies have legal protections to fire employees at will. The result of that and those legal protections is a hierarchy where it appears that company rights are over, have a higher priority than individual rights. Also, because a company is composed of other people, the owners, the shareholders, other employees, etc., they also have a right to operate a business that's free of negative influences. That is one of their rights as a company, is to try to present and maintain a positive image to the rest of the public. The ethical dilemma then becomes that dichotomy of an individual rights and the potential damage done to the company if that person is retained as an employee versus the company firing that person and trying to salvage or maintain their brand image. So with that all being said, and those precedents and those federal guidelines and everything looked at, let's analyze the examples that we started off the presentation with. In all the examples, the employees were fired. You could look at it from really one of three reasons. It was either a legal reason that they were fired, maybe some sort of ethical rationale was used by the company, in other words, damage to brand image, maybe it violated a company policy, morality clause, something like that, or perhaps there is examples where the firing was not justified, in which case the employee may have grounds to try to sue for damages or reinstatement into the company. So let's analyze it. Starting again with the Las Vegas shooting remarks, I would say that that one was valid because it's damage to the company image. She worked for a national company. I don't think that the company would really survive that type of reputation had she been kept on as an employee. The PR director commenting about Africa and AIDS, same thing. That's damage to the image of the company because it presents a highly negative image of that company that she worked for. Now, the marketing executive who flipped off President Trump in his motorcade, I would say that's questionable. The rationale that the company used for firing her was they're a government contractor, they were afraid they were going to lose government contracts. So that kind of gets into a reprisal sort of a situation. Not really a company policy, not really an image thing, but hey, we're afraid we're going to lose business. Now you're looking at firing that person for reprisal. She's actually suing the company for that very reason, trying to get damages for that. All right, Roseanne Barr and her comments. I think this is pretty clear cut. She's a well-known personality on a national TV show. I think a lot of viewers would have a hard time getting past what she said, and it would adversely affect viewership, and it would adversely affect the brand of the company. So I think this one's a fairly clear-cut example of a valid firing. Air Force member in Playboy, this is actually a legal issue, is what this comes down to. Air Force regulation states that you're not allowed to do that sort of thing in uniform. Some of the photos apparently were in partial uniform. So that's a pretty clear-cut violation of Air Force regulation. Additionally, there's other Air Force rules that say that you have to get commander's permission before you take a second job. This Air Force member did not do that and just did it on her own. So another aspect of that legal issue with this particular firing. Now, the San Antonio man that harassed the pro-Trump teenager, to me, I think this was actually a questionable firing. Certainly, I don't condone his actions, and there may be some legal ramifications if it shows that he was maybe assaulted the teenager or that sort of thing. But he was a part-time bartender at a bar here in San Antonio that probably isn't well known, certainly is not national. I think you'd have a hard time proving that damage to the company would occur had he been kept on as an employee. So I think that one's actually a questionable firing. The inflammatory Twitter post by the director, that also same thing, is an image issue by Disney. He's well known. He works for highly popular movies. I don't know that you can really keep an employee with that type of past on your payrolls. It's probably not a smart idea from a brand image standpoint. The police deputy wearing the hate group sweatshirt, that ends up coming down to an image policy sort of thing. Ultimately, what it does is it undermines public trust in law enforcement. Law enforcement should at least give that appearance of being unbiased. And when you have a deputy off hours, kind of going for an alt-right type of a hate group, that leads I think, a lot of questions, and you have a hard time maybe trusting that deputy or maybe even the department as a whole. Now, the professor critical of university leadership, that actually went to the courts, and that actually ended up being a legal issue. On appeal, the courts ruled that the employee was disruptive in the workplace. Although he had valid recourse to address concerns and criticize leadership, the way he did it was disruptive within the workplace, and therefore was a legal reason that he was fired. The letter from the Google engineer, that would be a brand image. That Google, obviously being a national image, I think would have a hard time justifying keeping somebody on who had such disparaging opinions about women in the workforce. Just not a good place for Google to be in. The Yelp CEO, the employee openly disparaged the CEO. It wasn't just a letter about low wages or high cost of living, but it kind of took a personal turn against the CEO. So from just a brand standpoint, from a maintaining authority over the company, I think that's really the rationale for that one. The demonstrator at the neo-Nazi protests, again, I think is a questionable thing. Clearly, that's unacceptable behavior, but the company that he worked for is a pizza place in Colorado, very small, not nationally known again, and the incident occurred, many states away in Virginia. So again, you might have a hard time proving that damage is done to the company based on this employee's actions. The fan who threw the beer can onto the baseball field, that's a brand image issue. The employee actually worked in a sports-related field, so having that type of behavior in the same arena or type of environment where he works undermines credibility for himself and for the company. Billy Bush's comments about women, I think that's pretty clear. He hosted a national TV show on a national network. Not good for the company to keep him on, given his disparaging remarks towards women from years ago. The social media director at the school, I think this one's actually questionable. The post itself that she put up was not very negative in tone. It was a little bit more lighthearted, I thought. Reading articles about it, the person that it was directed at didn't feel bad about it at all and understood. So there was really no fallout from this. So it might have been a little bit harsh to actually fire her for that particular action. So a summary of all the examples, there was a couple there that were actually bound by legal limitations. Most of them, though, were more of an ethical standpoint. You're talking about tarnishing the company's image, tarnishing its reputation, and that's really what most of them came down to. But as we discussed earlier, at least for now, company rights kind of outweigh individual rights. Therefore, they were valid firings, and the employee probably doesn't have much grounds to try to appeal or sue for reinstatement or damages or anything like that. There were a few, I think, that were questionable as I analyzed it, and they probably could be challenged. So, given that, um, right now the law favors companies over the individuals. Remember, the First Amendment does not protect individuals from company action. It only protects you against actions of the government. So I think people keying in on the First Amendment is a little bit inaccurate in its interpretation. As a result, I think companies will continue to fire employees based on questionable social media posts. Companies use social media more in hiring. I think it's going to continue that they'll monitor as the employee is there, and you may get fired as a result of questionable posts. So recommendations that I would have for employees, here they are. Realize that your individual protections are less than what you think. You're not as protected as you think you are. Know your company's policies about social media. I think this is pretty clear, but maybe people don't read the employee handbook as often as they should. But know what's going to get you in trouble. Know what you can and can't say or can and can't post about. Ultimately, be cautious. Companies view social media posts during the hiring process. They're going to continue to monitor them after they hire you. And avoid those potentially hazardous, harmful social media interactions. Anything that you post that's harmful or could reflect poorly on the company, you're effectively rolling the dice on whether that company is going to act and fire you as a result of that. So in this regard, the overall recommendation is err on the side of caution. And be very, very careful as social media becomes more and more prevalent in today's society. Here's a whole bunch of sources that I used. I'll click through those. Thank you for your time and for listening to my presentation.